Okay, the court is in session in two cases. First case is cause number 330-274, and the second case is cause number 330-812. Both cases are styled the state of Texas versus Eddie Ray Dankins or Eddie Ray Dankins Jr. Mr. Dankins, is that your full name? Okay, we have Mr. Dankins appearing via Zoom. His attorney, Mr. John Macy, is also appearing via Zoom. Mr. Macy, how are you doing?
I'm fine, Your Honor. How are you?
I'm doing fine. Thanks for asking. And Mr. Dankins, how are you doing?
All right.
Okay, now, Mr. Dankins, Mr. Macy, I have before me two motions that have been filed. Both motions have the same title. Both motions are titled motion suggesting incompetency or request for examination. And in both of your cases. Now, Mr. Macy, pursuant to Article 124 of the Texas Code of Criminal Procedure, it reads that all proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365 Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing rights and interests such as interest in security, preventing disclosure of non-public information, or ensuring that the defendant receives a fair trial. Mr. Macy, are you requesting that this proceeding, which is our informal inquiry, will be closed to the public?
Yes, Your Honor.
Okay, and the court is going to find that the defense has who is seeking to close the hearing have advanced an overriding interest that is likely to be prejudiced. That is, it will be disclosing non-public information, and the closure is no broader than necessary to protect the interests of the defendant, and the trial court have considered reasonable alternatives to closing the proceeding, and it makes the finding that is adequate for the closing and support the closing of this hearing. So at this time, pursuant to Article 1.24 and Lilly versus State 365 Southwest 3rd 321, this portion of